everyone. So in this video, I'm going to talk about some of the basics of antitrust law. Now, I'm an economist, not an attorney. I don't work in mergers and acquisitions or antitrust or anything like that. And so this is indeed basics of antitrust law. I want to provide sort of enough insight so that we are kind of familiar with the area and able to say some interesting things. But that said, sort of mostly the basics. All right, so previously we talked about aspects of collusion. Now we're going to think about some of the antitrust laws that government would bring to bear against cases of collusion. And I'll go over a little bit about the Microsoft example because it's sort of an interesting case study. And there's some interesting things that bring to light the economic reasoning surrounding antitrust. So why do we care about antitrust? A bunch of things. First off, it's really important in terms of, well, jail time, which you want to avoid, and the large sums of money that are involved. So here's some examples. The Roche Vitamin Division global fines in the range of $1 billion. ADM execs were sentenced to prison. This case featured in the movie The Informant. Google, potential European Union fine up to $6.6 billion, right? So large money involved. Importantly, antitrust issues are part of running a business, not even just big business, because the economy has a lot of linkages between different firms. And so there's a lot of really important considerations, especially, a lot of like startups working with different types of internet advertisements and whatever are going to run into situations where you're dealing with Google or Facebook or one of these other large companies. And so even if you've got a small business yourself as you'd be starting off, certainly there's a situation where you could be involved in a case by virtue of being on the other side, right? So 90% of antitrust cases are between companies. Even if you're not a violator, you should know, just in case you're on the other side. And there's some examples of startups such as Ben & Jerry's having the encounter with the large incumbent firm, Pillsbury, acting through Häagen-Dazs. It'll be a case I'll talk about a little bit. In terms of like the major antitrust laws, we have the Sherman Act, we have the Clayton Act, and we have FTC Act. So the way that I think about these relative to the class is I think it's more valuable to be able to talk about like the economics behind some of these things than to be able to recognize what are the provisions, for instance, of the Sherman Act. Or like I would never have a question where I say, oh, is price discrimination Sherman Act or Clayton Act? That's a stupid question. So the questions that I would ask is, well, how does vertical restraints work? Why would a company want to do that? Or, what are some of the issues associated with resale price maintenance? So like I'd ask you the economics of it, not like what does the FTC Act do? Come on, that's a Google question, right? What we're interested in is like the application. So, all right. Firstly, price fixing, absolutely something you can't do in the US. So this is where you'd have some type of explicit agreement about what the price of items is going to be. That's definitely illegal. So that's something you absolutely can't do, and that's going to lead to big problems. Also, the same is true with the functional equivalence of price fixing. So it doesn't have to be like explicitly setting the price. It could be things that have the same type of result, such as customer or market allocation. So suppose you think of like, maybe you've got an oligopoly between landscaping companies in the metro area, and they agree that one particular segment, like, okay, between this major street and that major street is our territory, between that major street and that major street is your territory. And then what they're effectively doing is deciding not to compete, and then this is going to set the price at whatever would be the monopoly price. So you can't do that. Bid rigging would be, so you've got maybe like a procurement auction or something like this where companies, whatever, are submitting bids to be awarded the project, but everybody knows in advance who's going to win. And so it doesn't matter whether you bid or not. We have, one company that's already been pre-selected. So what about implicit price coordination, stuff like tacit collusion? So I'll talk a little bit about how we might judge that. First, I've got some examples of price fixing. So here's a whole collection. NASDAQ market makers, U.S. airline reservation systems, Ivy League schools, ADM and licensing markets, like I said in the movie The Informant, Apple ebooks, LCD screens, and DRAM, beer, lots of bid rigging cases, and lots more. Look, if this was a standard class, I would go through each of these examples, but that's just to make the video super long, and everybody's got this ability to skip right over to Google. So if one of these strikes you as interesting, there's a lot of things to explore here. The Ivy League schools in particular, sharing information on students and then affecting the price of attending via the financial aid packages and grants that are offered. So they can't do that anymore. Right? All right. So I'll consider, like, going back to this comment, explicit price fixing, something you can't do. What about implicit price coordination, like such as tacit collusion? All right. Well, explicit price fixing, that is per se illegal. This is like the legal term, per se illegal. Can't do it. Other actions, such as being a monopolization, vertical restraints, these are judged according to rule of reason, which is basically, is there a compelling business justification for the practice, or is the specific purpose of the practice strictly to reduce competition? So this is like what I was saying with tacit collusion. There's a little bit of a legal gray area, meaning, what the antitrust officials, what the government, Justice Department are going to do is take a look, investigate if the case is brought to light, and then determine what's responsible for the pricing that you're seeing. Is there a reasonable business justification, or is it explicitly anti-competitive? Because the anti-competitive is going to make it illegal. All right, so the important point, it's not illegal to be a monopoly. A lot of people think it's illegal to be a monopoly. It's not illegal to be a monopoly. What can be deemed illegal, could be deemed illegal given the investigation, would be willfully taking actions for the express purpose of acquiring or sustaining monopoly status, right? So the idea is, like, are you abusing market power? Are you abusing monopoly power, or are you abusing market power to generate more monopoly power? So examples, like probably ones that are like most salient to people, would be predatory pricing. So here you've got the big firm comes in, or is in, lowers prices below their costs, and this is going to make it super unprofitable for the rival firms, and they have to exit, shut down. So there's examples with allegations against airlines, and then Microsoft setting the price of Internet Explorer down to 0. Problem here is if you set your price below your long-run dynamic marginal cost. So it's interesting. So I'm not a business attorney, not a antitrust attorney, obviously, but there's a difference between setting the price below your initial marginal cost and then what would be your long-run marginal cost, like your dynamic marginal cost. And the second wouldn't be as problematic, because you can think of a situation where marginal costs might be falling, such as if there's learning by doing. But that's something, if you're doing that in your business, you definitely want to consult with an attorney. All right, so tying. This is a specific form of bundling. So this is where you'd be bundling two distinct complementary products in order to leverage monopoly power in one market into another market. So bundling and tying are really similar. Bundling, obviously, this is, we talked about already, this is where you've got a couple of products that are sold together for a single price. Tying is like that, but tying has a separate characteristic where you are requiring consumers to buy the other product, and this has the motivation, or like the incentive, or like the requirement for consumers to buy is based on like the important monopoly power in one of the two markets. Sometimes, like with bundling, you have to sell the two goods together. Sometimes with tying, you could sell one of the products as standalone, probably the one you've got the monopoly power in. But the key feature to kind of think about the distinction between tying and bundling. First off, bundling is okay, not illegal. Tying generally is going to raise questions with the Antitrust Department. Tying involves leveraging monopoly power from one market into another market, and that's the larger transgression. The bigger issue with like bad monopoly behavior is, are you leveraging market power from one market into another market, or are you only using your market power within the market under consideration? And so part of what's making this happen is that they're complements, and then it'd be the type of thing where you have market power in one market, and then they have to buy your other product. Although there's competitors in that other product, maybe it's not compatible. It's a complement still, but it's not compatible with the first market. That'd be a situation that'd be likely to be looked at as tying. All right, so there's examples with Kodak, so copiers, and then selling service. So you buy the copier, but then you'd also have to buy their service. Although you could think of like local service providers that would be in competition, but there might be different types of problems where that wouldn't work, or because of compatibility, or they'd have some type of thing where you'd lose the ability to buy the copier if you didn't also buy the service. Windows and Internet Explorer. So if you bought Windows, then you had Internet Explorer. Other examples of leveraging market power from one market into another. Well, so Google Google's really interesting because because it's sort of a developing market. Typically when you think about antitrust and like abuse of market power, we're thinking about markets where people are paying for things. But with like search results and stuff like that, you're paying essentially with your time and attention. And so there's some interesting cases where you'd say, okay, well, so Google could has everybody's attention by virtue of searching for, using the search engine, and then could put their products or services high on the search result list. And so I think there's a lot of interesting there's a lot of interesting antitrust things, especially both in U.S. and then European Union. All right, so here's a problem thinking about Microsoft. So I don't understand how Internet Explorer is going to win. The current path is simply to copy everything Netscape does, packaging and product-wise. My conclusion is we must leverage Windows more. Treating Internet Explorer as just an add-on to Windows which is cross-platform, means losing our biggest advantage, Windows market share. All right, so I think this is probably from Microsoft exec James Alchin. I think this came in an email, and this is bad because this is basically talking about the goal of tying, right? So that's bad. Then I'll come back to Microsoft a little bit at the end. Here's the Clayton Act, price discrimination. So price discrimination for goods of like quality and cost is not allowed in intermediate goods markets, right? If the effect is to lessen competition. So yeah, maybe there's like a compelling sort of business argument for why there'd be some type of price discrimination, and then the burden would be on the firms to show that the effect is not to lessen competition. But this is where price discrimination, such as like between businesses and stuff like this, would very quickly could become illegal. So let's see. So there's some examples of issues such as retailers offering manufacturers offering lower prices to big stores like Walmart, and then like local retailers or other retailers in competition with Walmart now suffering because of the big price discount that allows Walmart to price low. Or retail druggists versus drug pharmaceutical companies. The issue is, though, there's very few successful cases. What has to happen here is you have to argue that there's this sort of anti-competitive motivation to lessen competition, and what the firms involved, what the large manufacturers would do, Walmart, whatever, drug pharmaceutical companies, whatever their argument would be, was typically that the different prices are due to different costs, like a volume sort of thing. They'd say, oh, well, we have different costs. We have different costs associated with going through this large retailer versus a smaller one, and so that is behind the price discount, and so really difficult to bring these types of cases. Other aspects of the Clayton Act have to deal with like vertical restraints, such as exclusive dealing. So the one that I will mention is like, think of startup Ben & Jerry's years ago, like in the 80s, versus Haagen-Dazs, and the allegation, like the case was about Ben & Jerry's arguing that Haagen-Dazs was threatening grocery stores and retailers that they would drop their entire product line if they carried Ben & Jerry's. So that's a problem. That's like exclusive dealing. So you can only sell our ice cream, and if you sell this rival's ice cream, then we'll pull ours. Haagen-Dazs had a large amount of market share. Haagen-Dazs behind that was Pillsbury, and Ben & Jerry's at that time had just been coming into grocery stores. Other examples, so Costco versus Toys R Us, Blue Cross Blue Shield in Michigan in 2011, EA Sports in the NFL, right? So EA Sports having exclusive rights to use the NFL images and players' names and coaches' names with the Madden franchise and so on and so forth. So there's some interesting cases here thinking about exclusive dealing. Another aspect of vertical restraint is resale price maintenance. So this would be a situation where you're requiring that the price of the particular good not fall below some amount. However, it's really difficult because so is there some efficiency-based rationale? Maybe there's some, and so there's situations where the law will provide for or will allow for some type of vertical price maintenance, and the idea being, well, it's different if we're thinking about price agreements between horizontal competitors, such as you have rivals that are choosing not to compete, versus if you have different aspects along the same supply chain, and then that's definitely sort of a different case. In terms of merger guidelines, so this is HHI based, Herfindahl Index based. So there's different sorts of mergers that are sort of explored and then explored based on the market share that changes before and after. So thinking about AT&T and T-Mobile, not allowed to merge in 2011, Sprint and T-Mobile 2014, Rite Aid and CVS in 2015, and airlines repeatedly trying to merge. Basic idea is they're looking to see what's happening to market share in the markets before and after the prospective merger, and what effect does this have on competition? All right, so FTC Act covering unfair or deceptive practices. So in the area of advertising, so definitely can't have a bait and switch campaign. This would be like where you offer one discount, one low price on some item, but then what you're actually selling is different and higher priced. Deceptive advertising, so just like outright deceiving customers in terms of what they're buying. Labeling is covered by FTC, so thinking about the issues around unproved claims, and so that's a problem. And these are all different sorts of things, primarily affecting how advertising would work, and then labeling of products and things to kind of pay attention to there. The basic idea is thinking about antitrust laws. There's things you'd want to explore and pay attention to as you're working on launching your own product, as the case may be. All right, going back to Microsoft, this is a monopolization case. To prove monopolization, authorities have to show possession of monopoly power in the relevant market, willful acquisition or maintenance of market power as distinguished from growth, development as a consequence of superior product, business acumen, or historical accident. So if they show that Microsoft is behaving anti-competitively, is what the authorities would need to show. If shown, there's treble damages. This means like whatever the damage is, literally times 3 to the injured parties. So is there a monopoly here? What are the sources of monopoly power? Indeed, at the time, Microsoft's market share in the Intel compatible operating system for PC was something bigger than 95%. Pretty close. I mean, that's pretty big market share. Typically, we think of that as being a monopoly. So there's some reasons to think that definitely we've got the structure we need for a monopoly in place, such as network and platform externalities, creating really high barriers to entry, right? This is like a situation where when you add another user of the operating system, this increases the value to everyone, and it makes it really difficult for another company to come in, because another rival operating system come in, because you've just got like much less compatibility and much smaller network. So that creates a really high barrier to entry. There's also this increasing returns to scale with really high fixed costs of developing the operating system, really low marginal cost of adding another user. And so they've made this really high fixed cost investment, and then have this have low marginal cost of adding additional users. However, being monopolist isn't a violation of antitrust law. And the existence of the Mac operating system and then other rivals suggests this isn't a strict natural monopoly. What's a natural monopoly? Natural monopoly is it's a cost structure. It's a type of industry structure. You think of like the utilities, like power, water, gas, as natural monopolies. And the argument here is that the market would naturally select for a single firm, and that if there's competition, this actually leads to a situation that's less efficient for consumers. If you believe that there's a natural monopoly, you would want only one firm in the market, because additional firms are going to make the market less competitive or less efficient. So the idea would be, if you have a natural monopoly, the problem with having additional firms is you have this inefficient duplication. So you can imagine, like, what if we had a lot of different competing water lines, right? or a lot of competing power line or whatever, gas lines. So inefficient duplication. And then the other issue is that with these natural monopolies, you have a really large fixed cost associated with developing and then operating in the market, and a really low marginal cost of adding an additional consumer. But to be able to recoup the really large fixed cost, you've got to have a large volume of customers, such that if you have multiple rivals, each trying to recoup their large fixed cost, now you've siphoned off the demand to the point where it might be unprofitable overall. And so the worry with natural monopoly is that it'll lead to diminished service, especially in the areas that are sparsely populated or there's fewer consumers or something like that. So, but because we have Mac operating system and then some other rivals suggest maybe, since they've persisted for kind of a long time, suggest that maybe the operating system market's not a natural monopoly. I wouldn't think it would be. Dramatic innovation often kills software products. And so the other thing is like, well, I mean, so yeah, we've got this really large market share for Microsoft. However, there could be some type of innovation in the future that would unseat them. Kind of type of situation where you have an entirely new product that you couldn't previously foresee, and then this kills off dominant software products, because what's happened, well, the dominant software product has invested this really large fixed cost. They've developed whatever it is. They've been working there from that point, and then another one comes in with a much better product, and then it's just impossible for the first firm to be able to match or to be able to keep up with the second one. All right, so thinking about leveraging the operating system monopoly, so going back to 1994, the first claim was vertical restraints. So Microsoft has very few barriers to entry, very few or no barriers between operating systems and application divisions. And so this, and also the applications programmers got details of the new operating system well in advance. So this created a big advantage for Microsoft. Also, the programmers had restrictive agreements where they weren't allowed to work on development for other operating systems. Claim number 2 is tying. So Microsoft tying sales of applications to the operating system's sales in a manner that substantially lessens competitions in the applications market. So requiring that if you're buying the application, you must also have bought the sales, you must also have bought the operating system, and then of course this is going to be anti-competitive. So there's a couple different things that would make. So how does this work? What's sort of reinforcing this? The first is like exclusionary licenses, so that if you're placing our operating system on your machines, you can't place any other operating system on your hardware at the company level to be selling these things. Minimum commitments. So if you are going to put Microsoft operating system on your hardware that you're selling, your new computers, you have to buy a certain volume. And this is sort of a capacity story, so they'd make it really big such that there just wouldn't be any, if you had extra machines, like you wouldn't have extra machines that you'd put a different operating system. I mean, you'd have to, all the machines would be, you'd basically have to, any hardware that you'd produced, any machine that you'd produced effectively had to be running Microsoft on it. Restrictive non-disclosure agreement. So I mentioned this a little bit with the developers. And so basically, like if you worked with Microsoft, you wouldn't be able to work with anything else for a really long time. And then vaporware. So vaporware is like saying we've got this cool software that's coming out and then it never does. But the very fact of floating the idea that you've got this software can sort of undermine the willingness of other firms to come up with rival software. Because think about it, you're making this really large fixed cost investment, and I'm not going to make this big investment to develop some new application if I believe the incumbent, Microsoft, is already doing that. So it'd be kind of a huge waste of money. So that's the threat of vaporware to prevent entry. All right, so this led to the consent decree. And so they're thinking about like kind of placing limitations and then, ultimately trying to get rid of these practices from Microsoft. Interestingly, we've got some other things going on, middleware threats. So this is like software that's going between Microsoft and then the applications it's running. So think of things like Java. So what was Microsoft's response? Well, tie Internet Explorer to Windows to keep Netscape off of every PC. You already have Internet Explorer, so you wouldn't need Netscape. and then to pollute Java so that applications written for Microsoft's implementation wouldn't work on the other operating systems platforms. So you'd have this incompatibility, and so you could only use the applications for Microsoft on Microsoft operating system platforms. All right, so problem. More from Microsoft senior exec James Alchin. So Memphis, MS, codename for Windows 98, must be a simple upgrade, but most importantly, it must be a killer on original equipment manufacturer shipments such that Netscape never gets a chance in these systems. So Judge Jackson, in the case, concludes Microsoft deliberately kept the application barrier to entry high, on the basis of like a lot of evidence, but also some of stuff like this. Remedies that were considered dealing with Microsoft, so restrict their pricing, restrict their contracting behavior, like between application developers, thinking about the pricing of Windows to the original equipment manufacturers, that there would be no price discrimination, further restrictions on the type of contracts and the exclusionary sort of restrictive non-disclosure agreement stuff, restricting the product design, untying Internet Explorer, forbidding the integration of other new products into Windows, such as beyond Internet Explorer, like other things that Microsoft would develop, opening up the Windows code, allowing entry, publishing, licensing, or break up the company into 2 or 3 integrated competing mini Microsofts into operating systems, softwares, and internet. Such as this is something that gets floated quite a bit. This was successful with like Ma Bell in the 80s, but we've heard some officials wishing to break up Facebook into 2 or 3 separate companies, and this is hard to do, and this didn't happen with Microsoft, obviously. Here's what happened. So in November 1999, Jackson orders negotiations given findings of fact. April 2000, negotiations fail. Jackson rules against Microsoft. DOJ asks for a breakup. Judge again agrees in June, issues the decision. February 2001, appeals court overrules ruling, sends to new judge. September 2001, Department of Justice announces it will not seek breakup. Judge orders more settlement talks. November 2001, settlement between Microsoft and Department of Justice announced, and November 2002, finally approved by the judge. Final settlement, share APIs and some source code with developers. So open up the code a little bit. 3-person independent technical committee created to oversee compliance with ruling. The committee has full access to Microsoft code, books, and records. And ultimately not that strict about future tying, basically requiring Microsoft to offer capabilities either to original equipment manufacturers or consumers to remove access to certain Windows components. So for instance, only requires the possibility for Internet Explorers to be hidden. Some states ultimately not that happy with the judgment, continued lawsuits. Eventually many settled, such as think of like California, or lost in court, such as Massachusetts. The EU Competition Commission continued fighting, eventually resulting in a ruling that Microsoft needs to untie some components, such as the media player, and release more source code at a reasonable cost. 2009, the EU Competition Commission starts another case against the bundled Internet Explorer. In 2010, Microsoft agrees to set up browserchoice.eu, and then 2013, additional $700 million fine for non-compliance. Okay. Well, that's good enough for now. I'm going to go ahead and conclude here.